obligation.
What are you talking about? What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. If I hear it again, I'm not going to let you represent yourself. I promise you.
Oh,
That's enough. I don't want to hear another word.
okay. I'd like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush.
All right, everyone. Today's case is a serious one. The defendant is facing the possibility of up to 30 years in prison. Instead of hiring an attorney, he chose to represent himself and rely on so-called sovereign citizen arguments. Given what's at stake, that decision alone raises a lot of questions. When someone is dealing with decades of potential prison time, most people would want experienced legal help. But in this situation...
All right, Mr. Baker, you're before the court today for your arraignment. And let's see. You're not... Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish to have a public defender to represent you?
No, sir. I'm representing myself.
All right. You're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is driving while license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Yes, sir.
How are you going to... The defendant seemed confident he could handle it on his own. Unfortunately for him, that confidence didn't match reality. The judge quickly shut down his arguments, and the hearing became tense and difficult to watch. Using sovereign citizen claims in court is risky at best, and especially dangerous in serious criminal cases. While some people attempt these arguments for minor issues, they have never succeeded in real courtrooms. Judges across the country have repeatedly rejected them, and established case law makes that very clear. Despite this, the defendant continued to rely on legal phrases and theories that don't hold up under the law. He mentioned things like the U.S. Code annotated, but simply referencing legal terms doesn't change how the justice system works. Adding commentary or annotations to the law doesn't create loopholes or exemptions. The same goes for ideas like...
Or if you'll raise your right hand to be sworn in.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business.
All right. What kind of business?
A cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to make this decision?
No.
All right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
Comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I end up pleading not guilty.
Okay. All right, you're filing motions.
Yes, sir. I
You have copies for the state.
Yes, I do.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's declaratory judgment. That's for the clerk only.
Now you're providing a copy of the state, everything you've given the clerk.
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
That,
if you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you.
Like eligible obligations or claims that criminal charges can be dismissed like unpaid tickets. Courts have consistently ruled that these concepts have no legal standing. Still, the defendant appeared convinced that repeating these arguments would somehow change the outcome. At a certain point, the judge stepped in firmly. Rather than allowing the hearing to spiral further, the judge removed the defendant from the courtroom and pushed for him to receive proper legal representation. While some might see this as strict, it was likely done to protect the defendant from making even more damaging mistakes. This raises an important question. Was the judge being too harsh, or was he preventing someone from completely undermining their own case? When a person's future is on the line, there's a limit to how much unsupported legal theory can be entertained. In the end,
He's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December. When's that motion day in December? December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9 o'clock.
It's no problem.
That's enough. I don't want to hear another word.
Okay, I'd like to also.
Another one, I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. Come on now. Y'all close that door where I can't hear him or he gets in any more trouble.
I'm not. And this case shows how dangerous it can be to rely on misinformation instead of professional legal advice. The justice system doesn't respond to internet theories or clever wording. It responds to established law and facts. What do you think? Did the judge handle this the right way? Or should he have allowed the defendant to continue? Let me know your thoughts in the comments. Thanks for watching, and I'll see you in the next one.